Justices of the Appellate Division, Supreme Court, First Department. Hear ye, all persons having business with the Appellate Division, draw near. Use your voice and you shall be heard. Please be seated.
Okay, good afternoon, everybody. Welcome to the Appellate Division First Department in person today. Nice to see those of you that are here, and I'm sure it'll be nice to see everybody that's here. We're glad to be here also. I am just going to call the calendar, and since not everybody is in the courtroom, I will say which cases are submitted and what the time is, and I guess if people are down place else, we'll hear that, okay? So this will just take a couple minutes. First case is People versus Angel Garcia, submitted. Bowe versus Valentine. Appellant has 5 minutes and 2 in rebuttal. The respondent has 5. W. Clovis versus Sandra D. is submitted. City of New York versus 1103 HOE. The appellant has 6 minutes and 2 in rebuttal. The respondent has 6 minutes. Grant versus Joyce, 5 minutes for appellant and 2 for rebuttal, and 5 minutes for the respondent. People versus Andre Johnson is submitted. Ramirez versus 2917 Grand Concourse. The appellant has 5 minutes and 2 for rebuttal. The respondent has 5 minutes. Nader and Sons versus Namvar. The appellant has 6 minutes and 2 for rebuttal. The respondent has 5 minutes. People versus Herrera is submitted. American Infertility versus Verizon Communications. The appellant has 6 minutes and 2 for rebuttal. The respondent has 6 minutes. People versus Ramon Caridad. The appellant has 6 minutes and 2 in rebuttal. The respondent has 6 minutes, excuse me. Agley versus 21 East 90 Apartments. The appellant has 6 minutes and 2 for rebuttal. The respondent has 6 minutes. Aiken Murphy versus State Farm is submitted. Figueroa versus City of New York is also submitted. So the first case for argument this afternoon is Monique Bowe versus Oliva Valentine. Counsel, you have 5 minutes.
Thank you, Your Honor. May it please the court, Scott Horn, counsel representing the plaintiff appellant Monique Bowe in this matter. It's our contention, Your Honors, that the motion court erred in determining as a matter of law that the defendant's acknowledged heavy use of the sidewalk in question to access her driveway and garage did not contribute to its broken and defective condition.
But the accident did not happen on the garage. It happened, on the driveway. There was no dispute about that. It happened on the sidewalk adjacent. So how does that interact with the special use of potential special use of the driveway?
Ultimately, it distills to a question of causation, Your Honors. I don't think the question of special use is at issue in this case. I think the defendants have essentially acknowledged that there was a special use undertaken here. So it distills to a question of causation. And whether the broken nature of the sidewalk was in the area in front of the gate or just adjacent to the area in front of the gate, there still is a triable issue of fact with regard to the heavy vehicular use and whether it created the condition.
Counsel, where do you say that your client fell? Does your client identify the crack?
Yes, Your Honor. So at page 115 of the record, you'll see that there's a photograph of the area in question, and she marked on the photograph where it was that she fell. And using that, the defendant is going to use that one way, and I'm going to use it a different way. So the defendant uses that to say, well, it was adjacent to the area in front of the gate. I use that.
But where the area where she fell, was there a special use of that area? I understand your argument, but
yes,
of that area, was there a special use?
The answer to your question is no, but is not a dispositive answer on the question of causation, because once you establish the special use, the defendant is duty-bound by virtue of that special use not to create a hazardous condition, whether it's within some imaginary boundary in front of a gate or immediately adjacent thereto. And so the issue of causation, as you know, Your Honor, of course, is inherently a triable issue of fact. In this particular instance, if you do look at that photo, you'll see that the entire area in front of the gate, as well as immediately adjacent to the gate, is in an egregiously broken and defective condition.
Don't you think that your argument would have been stronger if your client had actually fell in front of the gate?
Of course, Your Honor. Yes. If the plaintiff had fallen in the area immediately in front of the gate,
Where
then
the
yes.
special use, where there is a special use?
That is correct. However, the fact that it's just adjacent to the area is not dispositive. It's not a boundary dispute. It's not a question of you're over some imaginary line, therefore I don't have a duty. The duty is unquestioned. What is in question is causation. And we submit whether it's just over that imaginary boundary line, adjacent to it, or within it, that is not dispositive on the issue of causation. Obviously, a broken nature of a sidewalk over the years, 14 years, it's going to crack, and the cracks are going to travel, and it's going to become progressively more broken. The question is, what started that process? What contributed to that process? Defendant did not submit any evidence to establish that their heavy vehicular use of the sidewalk did not contribute.
Counsel, is that their burden, though?
I'm sorry, Your Honor.
Is that their burden?
No, Your Honor. Initially, the burden is on us to show that there is this causal link. And we came forward with evidence regarding 6 vehicles on a daily basis driving over the sidewalk immediately adjacent to the area to park in a 4-car garage and in the yard just on the other side of that gate. So we submit that under the totality of the circumstances, Your Honor, at a minimum, this engenders a triable issue of fact based upon the acknowledged heavy use in the immediate area of where that accident happened. And again, I refer to the photo. If you look at the photo, the entire area is broken. It's not just limited to the area in front of the gate. If the area in front of the gate was immaculate and the areas on either side were broken, I would agree with you. Matter of law, no causal connection. But that's not the case here. The case here is that it is very broken, very defective, and it's not limited to any imaginary boundary on either side of where the gate is. And so ultimately, Your Honor, we submit that given the question of causation cannot be determined as a matter of law, and there is a tribal issue of fact on this inherent question, that the motion for summary should be denied and that the order should be reversed. Thank you, Your Honor.
You'll have 2 minutes on rebuttal.
Thank you.
May it please the court, Christy Kensig from Devitt Spellman Barrett on behalf of defendant respondent. Your Honors, the lower court's order should be affirmed for 2 reasons. First, plaintiff concedes that there was no special use alleged here, so it cannot be used to defeat the motion for summary judgment. And second, even if it had been properly alleged, there is no special use which could have contributed to this condition because plaintiff has testified and the record establishes that the accident did not occur in the
Counsel,
driveway.
could you slow down just
How
a
do you
little?
Sure, I'm
respond to the
sorry.
argument?
Thanks, sorry.
Counsel, how do you respond to the argument that really what we're talking about is causation? There's an acknowledgement that there isn't a fault in the special use, but there's a connection between the cracks on the driveway in front of the gate that travels along the sidewalk.
Sure. So 2 things in response to that question. First, defendant testified that the condition in the sidewalk looked that way when she bought the house in 2000. So it looked the same when she purchased the house before she had access to the driveway and the 6 residents in the household were using the 4-car garage. Second, I think you can say that you're calling it causation, but it comes back to special use, that it's special use that you're using this portion of the sidewalk as a driveway, which then causes the sidewalk to have cracks in it because of the weight of the vehicular traffic. So again, this isn't a case for special use, even if we want to call it causation and say we have a question of fact as to whether the vehicles caused this defective condition. The condition where plaintiff fell and where she marked is not near the driveway. It's not where the cars parked on the sidewalk. It's not where they parked in the lot. It's not what they had to drive over to access the garage. And plaintiff's testimony, she repeatedly stated that she tripped in the sidewalk, not the driveway. She did not trip in the area where the cars come in or out of the driveway, and that she was next to the grass patch and hadn't yet crossed the grass patch when the accident occurred. So taking those things in together, first, again, not having alleged special use and therefore not being able to rely on it now, and then two, there is no question of fact as to special use because the accident occurred on the public sidewalk and not in the driveway. For those reasons, the lower court's order should be affirmed. Thank you, unless there are any questions.
Any other questions?
Thank you.
Okay, thank you.
Very briefly, Your Honors, the concept that this is not a special use case or that special use is not properly before the court is betrayed by the defendant's own summary judgment moving papers. They specifically addressed special use and attempted to meet their prima facie burden in their moving papers. There's no prejudice, there's no surprise. We address special use in opposition. They address special use again in reply. There's no question this is a special use case. Once we establish it's a special use case, it distills, again, Your Honor, to causation. Under the circumstances, the acknowledged circumstances regarding the heavy vehicular use in the area immediately adjacent to where she fell, we respectfully submit that there's a triable issue of fact in that regard, and as a consequence of that, the motion for summary judgment should be denied. If there are no further questions, I'll be happy to rely on my brief.
Okay, thank you both
Thank you,
very
Your
much.
Honors.
And have a nice afternoon. The next case for argument is City of New York versus 1103 HOE LLC. Good afternoon.
Good afternoon, Your Honors. May it please the Court, Susan Paulson on behalf of the appellant, City of New York. Your Honors, the Supreme Court erred in dismissing the city's action to foreclose on its relocation lien, and it made two critical mistakes in doing so. The first was in misunderstanding this action as an action against the LLC, when in fact it's a foreclosure action against the property, as you can see from the record on pages 46 and 47 of the complaint. The second critical mistake was in failing to recognize that when the city seeks to recoup its relocation expenses pursuant to a vacate order, through the proper filing of the vacate order is deemed notice of a potential future encumbrance as a matter of law. So here, the city sought to recoup its relocation expenses pursuant to a vacate order and did so properly by imposing a lien on the property under the Ad Code 26-305 subsection 4. And that section of the Administrative Code under subsection 4A allows the city 1 year after incurring its final relocation expense to file its notice of lien, which is what it did so here. But under 27-2140E, the vacate order statute, it says the proper filing of a vacate order ensures that future purchasers are on notice of a potential future encumbrance. The language
What
of
happened when the respondent here checked with HPD, I believe, and they said, well, nothing relating to that has come through our desk yet? That was not the right person to check with, and that was not enough due diligence?
Well, Your Honor, if you look at the record on page 139, the vacate order itself provides a phone number to call to inquire about relocation liens. Instead, this individual who did not identify themselves as an agent of the LLC appears to have reached out to somebody she was friendly with at HPD to ask if there was a relocation lien. The information that hadn't come across the emergency desk, to the extent that it suggested there was no lien, was in fact correct, because that was in 2015, and the relocation lien was not filed until 2017. To the extent that there was no emergency action on the property, that was in fact incorrect because a vacate order constitutes an emergency action. But the purchaser is deemed to be on notice of a properly filed vacate order, and there's no dispute here that the vacate order was filed in the Bronx County Clerk's office in the proper manner. And as
Does the lien law, counsel, does that invalidate the relocation lien?
I'm sorry.
The lien law, under the lien law, does the lien law on section 13.5, does that invalidate the?
No, Your Honor, not at all. The priority of liens provision in Lien Law 13.5 applies when an original owner holds money from the sale of property in trust to pay for improvements to property that began when the seller owned the property. Because the seller held that money in trust, a subsequent purchaser then does not have to satisfy the mechanics lien. That's what the statutory trust provision protects. Here, although the purchaser included a statutory trust provision, the purchaser doesn't even argue that any monies were held aside in the sale, nor could the seller hold money aside in the sale for expenses incurred by HPD. These are not expenses for improvements to the property that were commenced. I mean, both the plain language of the lien law, which applies to materials furnished or labor performed, and the structure of the provision that I just explained, the statutory trust provision, makes it clear that it has no application here to relocation liens. Although relocation liens are generally governed by the provisions of the lien law, there are many provisions of the lien law that on their face plainly don't apply, and there are other provisions that are modified by the administrative code in ways that the Court of Appeals in Rivera has upheld, different timing for the filing of the lien, different contents of the notice of lien. So the lien law, the priority of liens provision in the lien law does not invalidate the lien here. Here, the purchaser purchased on notice of the potential future encumbrance. And this is consistent. The purchaser focuses on the idea that the statute aims to punish the at-fault owner, which the purchaser was not. But consistent with the legislative intent to prevent that at-fault owner from evading responsibility for relocation expenses simply by transferring title, the at-fault owner is forced to sell with notice to future purchasers of the potential lien. And that's exactly what happened here. The properly filed vacate order deems the purchaser to be on notice of the potential future encumbrance. The purchaser is not a bona fide purchaser here that purchased in good faith without notice of the potential encumbrance. And because of that notice, they had the opportunity to negotiate a better sale price or to get other protective language in the contract to protect themselves. You know, they did or did not do so, does not invalidate the lien or prevent the city from being able to recoup its relocation expenses.
Any further questions?
I will save for rebuttal. Thank you.
You'll have a couple of minutes for rebuttal if you need it.
Good afternoon, Your Honors. Daniel H. Richland, Falkowski PLLC, for the respondent, 1103 HOE LLC. I think what's so interesting to me about this case is that we're dealing with a fairly arcane topic, which is lien priority relative to a relocation lien. And the problem with the city's entire position is you have to basically reread the administrative code and rewrite it in order to come to the conclusion my learned colleague suggests to this court.
How do you deal, counsel, if that's, I don't see the statute as being particularly unclear.
It's very clear.
So 26.305(4) is what you're grappling with.
Mhm.
It says that the city can absolutely put a lien on the building. It doesn't have to go over after the previous owner. So how do you deal with that?
Very simple, Your Honor. In 2 sections of that same provision, it details who can be an owner. And that list of owner is further limited in the first section of 305.
Here, this is a lien against, I'm sorry to interrupt you, but it's a
Please.
lien against property. It's not against an individual.
Correct. And that lien starts when they file the notice of lien, not when they file a vacate order. And the second part is that the actual language of 305 subsection 1 says...
Counsel, there's no dispute here that your client was on notice of the vacate order, right?
Correct. It's what the vacate order gives notice of.
Isn't that then constructive notice of the potential of a relocation lien, correct?
As you phrase it, yes. It's the constructive notice of a potential future lien. Correct.
So that does put your client on notice that the city can come back, assuming it's done timely, and assert this. So isn't that something that you would have negotiated or should have negotiated with the prior owner at fault to resolve that issue as part of the contract.
Right. I think the problem there, Your Honor, is that the amount of that relocation lien is not actually set forth anywhere. And as a result, we're talking about the rights of a prospective purchaser to know how much they should actually be negotiating.
But they may not have known at that point because the relocation costs, occur over a period of time, and the administrative code, right, says that you have 1 year from the last day that you pay.
It does.
So it's very likely that you won't know, but you do know that there is the potential for relocation costs, and so you have to negotiate with the seller a price that makes, that covers that up. I mean, you can't ignore that.
I'm actually so glad you brought that up because I think that pretty much underscores exactly what the problem with the city's argument is. As the city said, we did inquire. It's in the record. There's no dispute. The city says at the time we inquired, there was no lien, so we had nothing to tell them. And the very point you're making is, well, you know that there's a potential lien. So having asked the city, and the city says it's correct, we told you there's no lien because we told you there's no lien, what exactly should my client then assume is the amount of this inchoate lien that we're discussing? That's the very problem we are discussing because it's the right...
Counsel, isn't that a matter of business judgment as to what the value of the potential lien might be as opposed to a problem that inures to the city? I mean, if you take a look at what the website, the notice was posted on the HPD website as well as the email address that was supposed to be used by way of inquiry. That email address apparently was not used by your client to obtain information, and this is the notice. Here it is. If your client decided that the potential lien meant zero, change in the value of the building, that was a business judgment. If your client felt that it should be $100,000 or something else, wouldn't that be a business judgment as well?
Not in this case, Your Honor, and there's two reasons for that. The first is that the email address you're referring to actually does not appear anywhere in the record. There's no evidence in 2015 that was available. There's no evidence it was anywhere whatsoever at any point that my client could have found. That is a very critical and crucial point here.
So there was no email address on the website relocationexpenses@hpd.nyc.gov?
In my opposition brief, I specifically note there is literally no evidence that that's the case, and the city produced none. It's not in the record.
Your adversary says that there's a phone number on the vacate notice.
Correct.
Wasn't that a potential avenue of inquiring with respect to relocation liens?
The purpose of a vacate order is first to tell you that this property is no longer habitable, and two, to tell you that all the tenants have been relocated, and then three, it says if you want more information about this vacate order, call this number. It does not say, call this number to find out the amount of the relocation lien. The question there is, should my client be able to say...
Well, I mean, really, that's a matter of semantics, perhaps, because, I mean, you're aware that it's a non-inhabitable property, that it has all these problems. That's what you're buying into. You know that there potentially can be a lien. I don't see how you're not officially on notice, and that that you make a business judgment as to whether you want to buy the property or not, knowing all of that. You had all the information before you.
I'm glad you're asking, because that's not really correct. What we have is a situation where there's a vacate order. But as the First American versus Boyajian case notes, not every vacate order results in a relocation or a relocation lien. Now, I can appreciate you might say, well, that's a roll of the dice. You don't know. But that is the whole point. No one knows when they're seeing this vacate order whether that means that there is or will be a future relocation lien.
But you do know that there is a potential
Of course.
for a lien, and isn't
Of
that
course.
sufficient under the statutory structure?
No, actually, it's not, because under the specific 26-305 or 4A, it actually says the lien is not valid until it's filed. The vacate order is not the lien. The relocation lien is the lien. Until that day, there is no lien. So the problem I have here is that my client did what they were supposed to do. I agree that a vacate order requires a further inquiry. My client did that. The problem is the city allegedly correctly told them there is no amount of lien actually presently due. This is not on our desk.
Okay, I think we got the points. We're aware, but thank you very much.
There is a little more I do want to address
Well,
here.
we will rely on the record because you have used your time. Thank you.
Okay, thank you.
May we hear if you have 2 minutes for rebuttal?
Thank you, Your Honors. It appears to be undisputed that the vacate order provided constructive notice. And if you look at page 139 of the record, what it provided notice of was that the vacate order may cause a relocation or emergency repair lien to be filed. You're instructed for information to call a specific phone number, which was not called here. To the extent that that creates a disputed issue of fact, it needs to be resolved at either summary judgment or trial, but certainly does not create a basis to grant a motion to dismiss on any dispute as to whether or not a proper inquiry was made as to the relocation lien. Your Honors, the subsequent purchaser was on notice as a matter of law. Whether it did its due diligence or not, it cannot cannot invalidate the city's properly imposed relocation lien that was imposed upon the property pursuant to 26-3054, and the city properly seeks to enforce. The dismissal of the action seeking to foreclose on the relocation lien should be reversed. Thank you.
Okay, thank you both very much. Appreciate it. The next case for argument is Grant versus Joyce. Counsel?
May it please the court, my name is Paul Felicione. I represent the appellant's defendants in this case. This case involves a stop sign intersection. The intersection is a little different than most intersections. Summary judgment was granted as to liability as against my client, who had a stop sign. Now, in this intersection, it is quite unique in that my client was traveling northbound, and there's an entrance to a park on the other side of the intersection. To her left is where the plaintiff was coming from, and there's 2 lanes of moving traffic, one through lane, and to the left of that is
we
a
know the
turn.
facts pretty well.
Okay.
So there was a lady to her left, and there was a guy, a gentleman in a car on her right, and both of them waved her into the intersection, correct?
That's correct.
And your contention is that the defendant went into the left turn lane and to go around the lady who had waved your client into the intersection, correct?
That's correct.
Okay, so that creates an issue of fact, correct?
Yes, and it's also, yes, that creates an issue of fact because what Judge Briganti did not allude to in her decision was the testimony that he turned back at the last second into the moving lane of traffic, which our client said was occupied by another car that she was in. She had testified that her car had gone a little bit past the stopped SUV that was to her left, but she said she had not yet reached the extended left lane, if that lane continued, which it didn't. It ended quite some time before. So because she was still in that lane and he turned back in, and according to expert Gambardella, he's saying that the debris on the scene, the leaks on the ground indicate that is consistent with her testimony that the collision occurred at a point where she had not yet reached the left turn lane, if that left-hand turn lane was extended into the point of the accident. And additionally, had a car making a left-hand turn made that turn, because of the configuration of the roadway, the collision would not have happened until way up further. It would not have happened in the left.
The plaintiff contends here that, you know, his vehicle had right-of-way. You had a stop sign. And why isn't that a good argument here?
It's not a good argument because, well, one, he was using the left-hand lane and coming around into the lane behind a car he didn't have the right-of-way because he was not that car to the left. He chose to go around. She's already in the intersection now. She is in that left-hand lane, in that moving lane. So she's already in this intersection long before he gets there, so she has control of that intersection. Now you're talking about the left.
So it's your position then that since she's in the intersection, under the VTL, she has the right of way once she's
Exactly.
inside there.
And that's backed up by Gambardella's testimony regarding the points of impact, that she had to have been in that intersection before he came into the
Well,
intersection.
both cars, there was front end damage on both cars.
Right, but according to Gambardella, it occurred to the left front fender of the Bentley and the right front of the Camry, which would infer that the front hit the left fender front of the defendant's vehicle, which could only occur if the defendant's vehicle was in the intersection prior to the plaintiff's vehicle. But again, even if you accept what Judge Briganti states when she came to a conclusion, she does not allude to the fact that Kayla Joyce testified that he turned back in. And now it was brought up as to why would he turn back in, why would he be doing this? If you look at the diagram of what's up ahead, the road changes in configuration. You basically have typical route road that you see in Upper Westchester. But as you go to the right, all of a sudden there's a big island, and it seems to be like a neighborhood where it goes to one lane in each direction. So basically a car that goes around has to go all the way to the right to continue to go. So that's why he's turning back in to go around. It was brought up that that doesn't make any sense as to why he would be doing that. But the basic fact that her testimony is that the accident occurred still in the lane, backed up by the expert, backed up by her testimony that he drove into the lane, backed up by the physical evidence that it's the damage, the parts and the oil spills and antifreeze spills was in the lane, there's issues of fact all over. And then the defendant should have the right to bring this before a jury and let a jury determine where the accident happened, whether he turned into the lane and where it happened. And that's why her decision should be overturned. Thank you.
Okay, thank you. You'll have 2 minutes for rebuttal. And we hear from respondent, please.
Good afternoon, Your Honors. Robert Mena, representing the respondent here from Greenberg Law. So I see that there's absolutely no reason to overturn or disturb this decision by Judge Briganti of the lower court. She clearly read carefully all of the deposition testimony and considered the expert report submitted by the defendant appellant
counsel-
here.
Go ahead, go ahead.
I mean, your point, one of your points seems to be that the defendant had a stop sign and your client did not have any type of.
That's correct. So
But that isn't the end-all or be-all, is there? I mean, there is a recent case from this court in February, Luciano Mahoney versus Rossman, and even though the same type of thing where the defendant had a stop sign and the plaintiff did not have any type of traffic control, that isn't the end-all or be-all. Sometimes if the defendant is already in the intersection, you can't just say, okay, well, I don't have I can just keep going and smash into them. I mean, that's not
Well,
what the law is, correct?
in the facts of this case, there's no indication whatsoever that my client was speeding. There's no indication whatsoever that the defendant had her visibility blocked whatsoever.
But that's not the issue, isn't it? Isn't the issue, there's just competing versions of what happened. Defendant is entitled to every favorable inference on this motion for summary judgment, and her contention was that she was through the stop sign in the intersection when the accident occurred. So once she's in the intersection, isn't she entitled to the right of way?
Well, Judge Briganti specifically cited in her decision that the conflicting accounts go to comparative negligence based on Rodriguez. And if
But how does that go to comparative negligence? That just goes to the actual happening of the accident.
Well, the fact of the matter is that my client had the right of way, regardless of what lane he
In
was
other
in.
words, if a car is in the intersection, your client has the right of way and can go blow through that intersection even though there's a car in
I mean,
there.
I think that's what I just asked too. I
No,
mean, that
so-
just doesn't seem to make sense, does it?
Well, the defendant had the stop sign, so she had the duty to yield the right of way to the plaintiff. She admitted that she saw him coming towards the intersection, but still entered the intersection anyway. there's no testimony that he was speeding, and there was no testimony that she didn't see him or her visibility was blocked. So he had the right of way regardless. She claims that he was in the left turn lane, which, based on the evidence, he was not. His testimony clearly says he was not. But even if he was, she still had to yield the right of way for him. So it's just a matter of, just clearly basic principles that she had the stop sign. She had to wait until he cleared the intersection before entering it. It seems like this is coming into a matter of first in time, first in the right. If I get there first, then, the right of way just kind of gets thrown out the window. But, that's not really what the case law holds. If my client was speeding, or if there's any indication that he was speeding, or that her visibility was blocked, then yes, maybe that changes the circumstances of this case, but it doesn't. So, I just see that there's no issue of fact here, and my client had the right of way. He was proceeding straight through the intersection in the travel lane, and she entered the intersection against the stop sign. And, her version of the events, I just always, personally have to keep in the back of my mind that at the time of the incident, she was 19 years old, and she was just crashed her father's $200,000 sports car. So to me, I have to keep that in the back of my mind when considering her version. And
Yeah, but essentially what you're suggesting to us, that we should make decisions based on credibility.
no,
I mean,
well,
that's what it
it's
sounds like.
not a matter of credibility. It's kind of a matter of impossibility of her version. It's almost impossible, her version, to be factually true, that these two cars that didn't have stop signs stopped, waved her on, two cars facing in opposite directions, and then just left the scene after witnessing a crash without waiting for the police, checking to see if anyone's okay. I mean, is that really possible? And then the fact that my client is coming in the left-hand turn lane and then veers right, basically turning around this supposed stop car at a right angle and crashing into her, that isn't possible either. So I just see that, I just don't see how her version of events are actually possible. It's not really about a matter of credibility. It's just, let's look at what she's saying and just determine if that actually is physically possible here at this intersection.
Okay, thank you very much.
Thank you.
Counsel, you have 2 minutes.
I would just like to add one point, that the last few minutes of counsel's argument is a clear, good argument why there are issues of fact. He's saying as a matter of law it's impossible, and he's discrediting her testimony because of her age or because he doesn't feel it's possible. Those are all issues of fact for a jury. I have nothing further to add than I've already said, unless anybody has any questions.
Any other questions? Okay, well, thank you very much, counsel.
Thank you.
Nice afternoon. The next case for argument is Ramirez versus 2917 Grand Concourse. Counsel for plaintiff, you can go over to the podium. You may sit down. Okay, just introduce yourself and you may begin.
Good afternoon, Your Honor. May it please the court, Kenneth Gorman for the plaintiff appellant. There's no dispute that the IAS court had jurisdiction to consider the merits of plaintiff's cross motion to vacate or default for not complying with the January 23rd, 2017 conditional order of preclusion.
Under what provision of the CPLR did you bring a cross motion to vacate? I'm not clear that there is a section that you're relying upon.
5015, 2021.
But isn't it really a motion to re-argue?
I'm sorry, can you say that again?
Didn't you really make a motion to re-argue?
Well, it was a motion to renew because you had the plaintiff's affidavit. That was different facts. I mean, that was a new set of facts where she said that she was out of the country, and
But how I mean, the thing is, how is that really a new set of facts? Because she knew she was out of the country. I mean, it wasn't like something new that she learned. I mean, either she was out of the country or she wasn't out of the country, but she knew about it.
That's correct, but she didn't know about the IME that was scheduled, and unfortunately, she wasn't in contact with her lawyer, but
Did she have some obligation, knowing that she was involved in a lawsuit, to keep some type of communication with her lawyer? Apparently, her family members told her when she came back that her lawyer was trying to reach her. I mean, in this day and age, people don't usually go anywhere in the world and not have any contact with anybody. I mean, that just isn't really what's happening.
in retrospect, yes, it would have been better if she did have constant contact with her attorneys, but it wasn't. She
You need
wasn't.
to have constant contact, but at least, know that if somebody's trying to get in touch with her, she needs to get in touch with them.
I understand, and we just have to take into consideration that some of these clients aren't as sophisticated or educated as lawyers,
But
and
counsel,
they don't
surely-
understand.
Surely your client knew how long she was away from New York or from the country, and surely she knew who had allegedly passed away. That information is missing from her affidavit of merit, and here you have numerous failures to appear for an IME that go back to March of 2016. The cross motion is filed in May of 2017, if I'm correct. So do we have any certainty? Is there anything in the record that indicates for how long she was out of the country and what particular circumstances or what the relationship was? Because I didn't see it looking at the affidavit.
No, I don't, but I know that it was before November 2016, and there was a scheduling conflict for the first and second IMEs. There were not intentional defaults, and in Pabon versus AM Laundry Mac, this court affirmed the trial court's order granting the plaintiff's motion to vacate her default for failing to appear for a physical examination in accordance with the conditional order of preclusion, and affirming that order. This court noted that the plaintiff demonstrated a reasonable excuse for her delay in returning to the United States.
But where's
arriving
the
12
reasonable,
days-
where's the reasonable excuse here, counsel? You're talking about new information that came about, and there's still new information that's missing, isn't there?
Aside from...
I'm not necessarily agreeing with your characterization of quote-unquote new information, but there's a tremendous amount of information that's missing.
I can't answer. I can't explain what's not in the record. I just can't do it. But she made it crystal clear that she is ready, willing, and able to pursue her legal remedies. And this case has merit. I mean,
Wasn't there also an additional problem in this particular case where the defendant had served a CPLR 3216 notice, and that your client, you had failed to respond to that or make a motion to extend the discovery period? So isn't that an additional problem in this issue?
well, I mean, yes, but in retrospect, they could have made a motion to extend, but that's not. I mean, CPLR 3216 is much more forgiving than CPLR 3126, and the case law that we cite in our brief has circumstances that are much more egregious in this case. Bottom line is that she has a meritorious case, and under Pabon, she does have a reasonable excuse.
Okay, you will have 2 minutes for rebuttal, counsel. All right, thank you very much. We'll hear from
Okay.
the respondent.
May it please the court. Good afternoon, Your Honors. Ross Barber for Defendant 2917, Grand Concourse, the respondent. Basically, no matter what we call this, the underlying motion or cross motion, motion to renew, motion to vacate, motion to re-argue, the facts presented in it are not sufficient to overturn the court's conditional preclusion order. It's long been held that conclusory and unreasonable, or excuse is conclusory and unreasonable where it fails to identify what efforts were made, when they were undertaken, or when counsel lost touch with the plaintiffs. All we know is sometime in maybe 2016, maybe 2017, Ms. Ramirez went to the Dominican Republic because a close family relative of hers passed away. We also know that she never told her attorneys that she was going. She didn't reach out while she was there. This is a period of months. We're not talking about an emergency situation where she goes for a day or two or a week. It's a period of months. And she never appeared. She never contacts her attorneys, and she blows the 60-day conditional preclusion order. The 90-day notice also goes into effect, and it's a question of timing. They didn't make any of these motions until after both the 60-day conditional preclusion order and the 90-day notice expired. So we were essentially left with having to make this motion for summary judgment because the plaintiff cannot prove her damages, and that's where we are right now.
Does anybody have any questions? All right, well, I guess you will rely on your briefs, which we've had an opportunity to read, so thank you very much. We have no questions.
Thank you.
There's nothing much more for me to say, but I just would like to stress that the plaintiff arrived back in the United States shortly before the defendants moved to dismiss her complaint, and she stated that she was ready to appear for her IME. Under these circumstances, given the court's policy of deciding cases on their merits, it would be inequitable to deprive the plaintiff of her day in court since she has a meritorious claim. And I would argue that under Pavone, she does have a reasonable excuse. Being out of the country, being in the Dominican Republic for months because of the death of a family member, helping family members out in the Dominican Republic, she wasn't in contact with her attorneys.
Counsel, do we know that she was in the Dominican Republic for months?
She said that in her affidavit.
Do we know how many months?
No, I can't say that, but I mean, it would be at least 4 months from November 2016 to March 2017, mid-March 2017. A 4-month delay. Under these circumstances, not suiting the plaintiff, she has a meritorious case. I mean, her ceiling fell on her head. She sustained severe injuries. She should have her day in court. Thank you.
Thank you. Thank you both. Next case for argument is Nader and Sons and Cisco Enterprises versus Namvar. Good afternoon, counsel. You can introduce yourself and you can begin.
Good afternoon. Daniel Liebersfeld with the Dratch Law Firm on behalf of defendant appellant Homiun Tony Namvar, and I'll refer to him as Tony hereafter. I'd like to bring up 3 points which are either not disputed or are beyond any reasonable dispute. One is that at issue here is a combined loan of $12.5 million from the lenders to a company called NAMCO, which we've referred to as the NAMCO loan. Second, my client Tony is only a guarantor on the NAMCO loan, so therefore he is only secondarily liable. And third, the pledge agreement, which secured the NAMCO loan, provides that the collateral includes what the parties have referred to as the Chevalier instruments, or to be fair, I adopted.
Why did the plaintiffs pay for the Chevalier instruments pursuant to the PSA then? What is the...
Well, all right, first off, it's a little bit misleading, I think, to say that they paid for those claims and that, they didn't, after the execution of the PSA, there's no indication that a check was written for $250,000. What the PSA actually says is that to the extent that the lenders collect on the Chevalier instruments. $250,000 is called retained proceeds that goes to the bankruptcy estates. Now, the reason why they did that was it was essentially getting the cooperation of the trustee, because remember, these are obligations that ran to affiliates of NAMCO.
So, counsel, you bring up the bankruptcy. What position did the defendant take with respect to the pledge agreements in the bankruptcy proceeding as it relates to the Chevalier instrument?
Well, what I think the overall position is that the bankruptcy and the PSA is something of a red herring.
But just answer the question I asked.
Yeah, I'm sorry.
So the question is, what position do your clients take with respect to the instrument in the bankruptcy proceedings? Did you say that they were covered by the pledge agreements, or did your clients say they weren't covered by the pledge agreements?
The Chevalier instruments are covered by the pledge agreement. I'm not sure if I understand the question then.
In the bankruptcy proceedings, right?
Yes.
The partial settlement agreement is a product of the bankruptcy proceedings. What position did your client take in the underlying bankruptcy proceedings?
My client was not a party to the bankruptcy proceedings. He was not a party to the PSA, and he's not a party to the bankruptcy proceedings.
But what position did the party that was seeking the protection of the bankruptcy code take with respect to the instrument?
Well, the trustees, I think the trustee, I get that's the party, I guess, who is who is stepping into the shoes of NAMCO and NAMCO's affiliates, who are the debtors in the bankruptcy. And I don't want to speak for the trustee, but
what about NAMCO? What was NAMCO's position? Wasn't NAMCO's position that it wasn't covered by the pledge agreements, and as a result of that, there was a partial settlement agreement dealing with the instrument?
No, not at all, Your Honor. I think the PSA actually says exactly the opposite. That it says the affiliates of NAMCO say, actually, so one is NY18. It says, NY18 agrees not to oppose or contest the validity of the pledge agreement, and acknowledges that the collateral includes, among other things, NY18's rights in the Chevalier notes and its collateral. And you have a very similar position, which I don't need to read verbatim, that applies to Beshmada, where Beshmada says that the collateral includes any and all rights of Beshmada with respect to the Fifth Avenue LLC, including Beshmada's rights as a member of the Fifth Avenue LLC, and that would include the true-up provision. So the answer is the PSA recognizes that this is collateral, that the Chevalier instruments were collateral for the NAMCO loan.
Okay.
And it says so explicitly. So we get there, and the lender essentially, advances three main arguments as to, so basically based on these, three undisputed facts, that, ordinary principles would say that my client as a guarantor receives a credit to the extent that the lender has collected against collateral that secures the same loan. Now, the lenders advance three arguments why this principle doesn't somehow apply to them. First, that they claim that the Chevalier instruments, they obtained them through an assignment rather than through a foreclosure action. They also assert various claims of preclusion. Then they claim that the Tony guarantee waives quote-unquote defenses and quote-unquote settle.
What about the fact that there was a proceeding, there was a judgment in California, right? And they moved to renew, I don't know if that's my...
Yeah.
The judgment in California. And the defendant, your client, had an opportunity to raise anything that he wanted to raise there, and he didn't put in any papers, and so that judgment was there in California, and then they just want to bring the judgment over here to New York. So, doesn't he lose the right to make any of these arguments? He should have made them in California, and he did not?
Well, respectfully, Your Honor, it is not a judgment in California. Again, the California Court of Appeals makes sure that this is a application to renew, which is not, that's what the Goldman versus Simpson case says, what they all say. is that it is a ministerial act by the clerk. But in any event, that action did not.
Wait a second. But it might have been a ministerial act by the clerk, but if they chose to bring a motion, then your client was on notice and could have raised any defenses at that time, which he did not do.
Well, one point I would make, Your Honor, is that, first off, that there was no, collection or no even judgment against the Chevalier guarantee at that point. That happened several years later. And, I think a month earlier there might have been a judgment on the Chevalier note. But even so, again, that would be, the argument there would be collateral estoppel, not res judicata. And the issue would have to be if that specific issue was actually, raised and necessary to the court's decision. Wasn't raised. It was not necessary to the court's decision.
Okay.
Ultimately, this
Counsel,
goes to.
We'll give you 2 minutes on rebuttal. You've
Okay.
used your time. Thank you. Okay.
Good afternoon, Your Honors. Jeremy Cohen of Seyfarth Shaw for Respondents Notter Cisco. I had a somewhat long outline prepared to start today, but I want to address the questions that Justice Singh addressed to my colleague and that he wasn't able to answer or maybe misstated his answer. First of all, there was a payment of $250,000. The original iteration of the PSA had this shared proceeds, but when the California Bankruptcy Court approved the order, that provision was substituted out with a immediate cash payment of $250,000. So we absolutely bought the Chevalier instruments. They were no longer collateral at that point, if they ever were. Counsel also said that in the pledge agreement, the Chevalier instruments were identified as collateral. Well, they're not. They're not there specifically. There's a broad description of.
There's an argument to be made that they could be, because there's an argument to be made that they could be part of the pledge agreement.
Absolutely, and that was.
So that's what my questioning is with respect to what occurred in the bankruptcy proceeding, and is there an inconsistent position being taken at this time?
Absolutely, absolutely. So it was actually our position that the Chevalier instruments were collateral, but NAMCO, which is his client, was the principal of NAMCO. They said no. Their trustee said no. He said that Tony, his client, was not a party to the bankruptcy proceeding. He actually was there. He was there. He had counsel. He was getting notice, and we cite that in our briefs where his counsel, Christopher Reeder, out in California, was getting notice. He was on notice of the approval of the PSA, and Your Honor asked, what was Tony's position? He took none. If he had appeared in California Bankruptcy Court as a principal of NAMCO and said, hold on, the Chevalier instruments are collateral, then maybe we wouldn't have had to pay the $250,000. Maybe we didn't have to pay new consideration. Maybe we didn't have to spend 12 years litigating. He is absolutely precluded from raising that issue now for that reason, as well as for his failure to contest it in California when it was renewed. He also failed to contest it back in 2009 when Justice Branston entered the original order in the first place. It doesn't provide for offsets, doesn't provide for credit, doesn't provide for joint and several liability. It is way too late for 12, whether you want to call it 12 years from 2009, 11 years from 2010, or 6 years from 2015. It is way too late. He talks about the preclusive effect of California. Strangely, they cite this case Ferraro, a California case, on this issue of a clerk's default. A clerk's default is not an issue here. We're talking about a judgment, and there absolutely is a judgment in California as a result of all of this. He is precluded under Ferraro, his own case. He's precluded under a case Popa, which is a federal California case from 2019 that we cite. It's just too late. He's also wrong on the facts that by the time of the PSA, the Chevalier instruments remained collateral for the loan. They were not. The $250,000 in fresh consideration made it so that was not the case anymore. Thank you, Your Honors.
Okay. Thank you very much. Counsel, you have 2 minutes to respond to any of.
Sure. I'd like to quote the California Court of Appeal as to what a renewal judgment is. And this is Goldman versus Simpson. It says, it is an automatic ministerial act accomplished by the clerk of court, and it does not constitute a new or separate judgment. So there's no judgment there that has any preclusive effect, and that's what the...
That's not what happened in this case, is my understanding. It could be it could be a ministerial act, but that's not how it proceeded. It proceeded by motion on notice, with the defendant having a full and fair opportunity to lodge his objections.
Well, I think that's what happened in Goldman, too. He had the, it was, the issue there was that the Goldmans of Goldman Simpson had a judgment against OJ that they wanted to renew. He was in Florida. They gave him notice, and he said that you don't have personal jurisdiction over me anymore. And they said that's irrelevant because this is not an action. They're renewing a judgment that they already had. So when we quote Ferraro, that is it is the same principle, that in Ferraro they were dealing with an action of the clerk of the court, and that's what happened here. Now, I'll touch on the set-off argument. Again, we are not seeking a set-off. This goes to the damages that are actually owed, and there's a quote from the Second Circuit Court of Appeals, which I guess my time is limited, but it just says that we're not arguing that the lenders owe us any money under any separate deal. We're arguing about the damages that are owed under this note. And then ultimately, they don't really address the primary issue, which is I don't see how they're not getting a windfall if the judgment of the motion court is upheld. They've collected $7 million on the Chevalier notes that undisputably are named as collateral under the pledge agreements, and they argued so, and the PSA itself says so.
Okay, I don't think anyone else has any further questions. Okay, we'll take another look at the briefs. Thank you both very much for coming in this afternoon. The next case for argument is American Infertility versus Verizon New York. Okay, counsel, you may begin.
May it please the court, Stephen Lester, Laradola Lester and Associates, for the appellants. The motion court made 4 critical mistakes. First, it required that the opponent of a motion for summary judgment establish lost profits. That wasn't CHR's burden here. It was to show instead that lost profits are just capable of measurement with reasonable certainty based upon evidence of known reliable factors without undue speculation.
So what's the evidence here that supports lost profits?
The evidence is the preliminary analysis done by the accountant, Steve Mizrak, which analyzed the financial data on a quarterly basis. And this goes to an error that the motion court made. The motion court only cited annual financial data regarding alleged profits for a construction delay that was 4 to 6 months. That was, again, the problem is that the motion court actually engaged in the substantive analysis itself instead of waiting for the expert to testify about the unique nature of a fertility practice, how a construction project affects...
Once there was a summary judgment motion made by the defendant on these issues, wasn't it your burden to lay bare your proof, which it doesn't seem that you gave any type of analysis or expert evidence to support this claim on the motion for summary judgment?
We did provide an affidavit from the appellant's accountant, Stephen Mizrak, that stated that he is awaiting the completion of discovery. Again, discovery was still ongoing.
But bottom line, as my colleague is suggesting, he does no analysis of lost profits, correct?
Correct. He had not undertaken the analysis.
Well, then how do you lay bare your proof?
Again, we had gotten no expert disclosure statement. We produced all the raw financial data that the expert would use. We met our burden, and we have an affidavit that in this business, which is At that time, 15 years of financial performance, the lost profits are capable of being computed without undue speculation. This case is most like Sandwep Restaurant, which this court decided, I believe, in the mid-90s. And in that case, this court held regarding a potential lost profits claim regarding a restaurant that was forced out of operation for only 1 week. It said in the case of a restaurant which has been a going concern in the area for 13 years, the prospect of establishing a basis for at least some lost revenue over a given 1 week period is not so speculative that the claim should have been dismissed on a motion for summary judgment. And that's the same here. CHR is an established medical practice. The construction interfered with its operations.
Counsel,
Yes.
isn't all of this information uniquely within the possession and control of your client? I mean, what would discovery bring about that wasn't already known? The status of the finances, the alleged lost profit, the
again,
profit in the past. All of this information is within the purview of the plaintiff, and yet Mr. Misrach, when he testified, he said that he never analyzed the impact of the construction project upon the profits and the financial standing of the plaintiff.
He was deposed as a fact witness to authenticate the financial documents. He was not deposed as an expert witness to opine about lost profits. We did not get an expert witness disclosure under 3101. We produced all the financial data from which he can provide an expert analysis regarding whether...
But didn't you really, I sort of go back to what I said before, didn't you really have to provide more? You had to lay bare your proof, not just say, here's a bunch of documents, go figure it out. Because wasn't there some evidence that, in fact, your client's revenues were rising? I mean, you needed to give them some type of expert analysis, which I think Judge Gonzalez was saying. You didn't need discovery for it. It's your client. You know what was going on with the business. Why couldn't you have given them some type of more definitive information to back up your lost profits claim?
Well, again, that's not our burden on summary judgment. Our burden on summary judgment is to show that lost profits are capable of measurement with reasonable certainty. It's not to establish that we actually suffered lost profits. If that were the case, we might as well, and that's the problem here, hold the trial at the summary judgment stage. And that's the same thing with the construction contract, Your Honors. The bottom line is that the court's error was that it treated this case as really a breach of contract case when it's a tort case. Verizon is not allowed to make the benefit of the type of contract that it was not a party to. The LLC was a...
I don't understand you, counsel. So, you know, if you look at the photographs, the site was a mess.
Yes.
Okay? But then you have a fixed price construction contract where nothing's going to go up and nothing's going to go down. And the only issue really is whether the delay affects the price of materials, for example, you know, inflation, in other words. And that you're allowed under this decision. So I still don't understand where the loss is. I mean, that's putting aside the aggravation of a nasty-looking and difficult area to work in.
Certainly, but...
I'll let you answer the question. Go
Thank
ahead.
you, Your Honor. The key here, Your Honor, is that the construction project caused a delay. The type of contract that we had, whether it was fixed cost or variable, is not a defense of Verizon. We had a trespass committed against us. Verizon's responsible for all damages that flow from that trespass. We have in evidence the additional construction costs. There's a summary of the invoices that were rendered by the contractor. There's a summary of invoices rendered, additional invoices from the architect, from the construction manager, and from the expediter. These are all the tort damages that flow from the trespass. And again, it has nothing to do with the contract, which Verizon was not a party to.
Okay, thank you, counsel. You'll have 2 minutes for rebuttal. We'll hear from the respondent now.
Good afternoon, Your Honors. John Vandertine for Respondent Verizon. Let me just take 15 seconds to say it's great to be back, okay?
We agree.
I think that needs to be said. I appreciate it. I think Justice Gonzalez and Justice Kapnick, you've kind of hit the nail on the head here. The fundamental issue here is that on this summary judgment motion, the plaintiff opponent of the summary judgment motion did not do what he is required to do under bedrock principles of summary judgment law. That is, there was no offer of actual facts sufficient to create a material dispute of fact.
Counsel, what about the summary that was prepared by Sinfonia?
Well, that summary that was prepared by Sinfonia, and I want to come back to what I was saying, but to answer your question, the summary that was provided by Sinfonia allegedly shows that there was interference and delay. That's all it shows. It shows nothing about additional costs or what those costs were or how.
It doesn't quantify the cost? I'm looking at the report from...
I thought you were referring to their December 2015 report with photographs, et cetera.
No, this one is the February one.
The summary that was provided by prepared by Sinfonia in, I think it was December of 2015, which is at one-page schedule, is not evidentiary proof. It was a document created for litigation. It is not admissible proof in terms of evidence to support.
They seem to indicate on, if I'm referring to the same, page 84 in the record, it does talk about lost profits caused by delay. It says $250,000, but there was no, I don't believe there is any backup to show what possibly could have been those lost profits. This is not that. I looked at the report also with pictures. This is just the one page.
I believe you're right, Justice Kapnick. I was speaking to the wrong report when I first began my answer, Justice Moulton, and I understand the document that you're referring to. And as I said, the affidavits were that this was a document created for plaintiff's counsel for purposes of litigation. It is not admissible evidence. And when in their testimony, the principals of the plaintiff were questioned about the lost profits here, they were kind of all over the map. They didn't know whether this was revenues. They didn't know whether this was profits. They said the number was wrong. And so that document is not evidence and is not proof. Let me also go back to correct one misstatement by my colleague here with respect to the affidavit from Mr. Mizrak, in which my colleague said, well, he didn't provide any analysis because he was waiting for the discovery. Mr. Mizrak's affidavit was prepared in May of 2020. That was 6 months after he was deposed. He was the last person deposed. There were 8 depositions. All of the prior deposition testimony was available to Mr. Mizrak and plaintiff before he was deposed in June and November of 2019. So he had all of the information. In addition, he was the one who had prepared the financial statements and the tax returns, tax returns that supposedly would be evidence of any lost profits costs. And in his testimony, he repeatedly said, I don't know. I asked him about the tax returns. I asked him about the financial statements. Can you point to anything here that shows me that there is any impact upon these financial statements or the finances by Verizon and its cable? And his answers were repeatedly, I don't know. I can't tell. I don't know, throughout his deposition testimony. And again, the fundamental issue here is the summary judgment standard issue. Were they required to prove their case? No. But they are required to come up with admissible facts that show a material factual dispute, which they abjectly failed to do. And this two-page affidavit that they submitted for Mr. Mizrak, is completely non-probative and inadmissible under the standard set forth by the Court of Appeals in the Diaz versus New York Hospital case, which is that an affidavit submitted by an expert on a summary judgment motion that is not based on facts and is merely speculation is non-probative and cannot support the summary judgment position of that party. And here, this two-page affidavit that Mr. Mizrak submitted doesn't provide any analysis, is not based upon any facts. In essence, what he's saying is, well, let me get back to you on that issue later. But you can't do that on summary judgment. You can't, this wasn't a dismissal motion where you could, articulate a theory and say the facts come later. This was a summary judgment motion upon which they were obligated to submit evidentiary facts, admissible facts, that created a material factual dispute, and they abjectly failed to do that. Our proof showed that there were no lost profits, that there was no construction cost delay on this fixed price contract, and they had nothing to respond to that with.
Okay.
Thank you.
Thank you very much. We'll hear from the appellant. You have 2 minutes.
Thank you. A couple of quick points. The summary at the record on page 201 was prepared by the construction manager, Sinfonia, based on all of the invoices submitted by the various vendors on the construction project. Summaries of invoices are admissible. In fact, the court at the outset said that all of the parties' exhibits are admissible. This is evidence of the increased construction costs caused by the delay. It's certainly sufficient to create an issue of fact regarding the damages caused by the trespass. Regarding Mr. Mizrak's testimony, correct, he did not say that I have calculated lost profits to be X. He did not. He, as counsel said, discovery completed at the end of a year. He was then deposed, and he was the last party to be deposed, but then the summary judgment happened during tax season. Regardless, the question here is, what is our burden on summary judgment? We have an established business that's been around for 15 years. We had produced all of the evidence. And again, at this point, there's a reasonable basis by which he may be able to compute lost profits. That's something that should go to trial and not be decided. The court actually said in its decision, the data do not support lost profits. And that's the very problem here, is that the court went a step too far and looked at the data and said, I don't see any lost profits. That's why we need expert testimony at trial, so the trier of fact can decide. Again, here we have the business that's been around a long time, unlike a lot of the other cases where you had lost profits based on a breach of contract where they have to be expected by the parties. This was a tort, not a breach of contract. Thank you.
Okay, thank you both very much. We'll take a look at this further. The next case is People versus Caridad. Good afternoon. You may start. Mr. Weiner?
Good afternoon, Your Honors. I'm Benjamin Weiner on behalf of Appellant Ramon Caridad. The plea court never told Mr. Caridad the maximum sentence he could receive if he failed to appear for sentencing. Since the sentence is the paradigmatic example of a direct consequence of a guilty plea, this omission invalidated Mr. Caridad's guilty plea.
Counsel, you would concede that the initial judge did say to him, listen carefully, quote unquote. Insofar as the sentence is concerned, of course, it's conditioned on his appearing at the appropriate time and place. He said that.
Absolutely, Your Honor. And Mr. Caridad would have understood that it was a condition of his guilty plea that he appear for sentencing.
Did he think he'd get a more lenient sentence if he absconded for 19 years and then showed up?
No, but Your Honor, he didn't know what sentence he could actually receive. He needed to know more than just that the sentence could be enhanced. He needed to know what the consequence of his guilty plea was. What sentence was he going to receive, or could he receive? That is the most basic piece of information that a defendant needs in order to plead guilty.
Are you saying then that the maximum exposure should have been delineated, because otherwise there is no way to say what the enhancement might be? You don't know. You expect that the defendant's going to return for sentencing.
Yes, Your Honor. That's all the court needed to do, was say the maximum sentence on the charge to which you're pleading guilty is 12 and a half to 25 years. That's all the court needed to say. That was it. That would have been sufficient to advise Mr.
Sorry to interrupt you, counsel. Did you move on those grounds below?
No, Your Honor, but...
So is it preserved?
Well, Your Honor, we contend that this did not need to be preserved, but this was absolutely ineffective assistance of counsel if this is something that actually needs to be preserved.
But have you made a 440 motion?
No, Your Honor, and it's not necessary in this case. Counsel moved for plea withdrawal here. Mr. Caridad wanted his plea back, and in fact, the DA's office included the plea minutes in their response to that motion. Counsel had everything he needed here to make this motion, and there's simply no conceivable strategic reason to make a motion for plea withdrawal, but not to raise the meritorious claim that will entitle your client to that relief. And I think it's really significant that respondent doesn't cite any potential strategic reason. They can't identify any theory as to what counsel could have been thinking here. I think it's obvious that it's just an omission, and under these precise circumstances, this is exactly when...
Is there a case that specifically says what you are saying, or do the cases not say that you need sufficient information based on the record as a whole and to, give the defendant an accurate impression, but does it specifically say that he had to be told exactly what the maximum sentence would be if he did not show up and absconded from court?
Well, yes, Your Honor. I mean, I think that the Renville case, which we cited in our brief, says that. This was a conditional plea case. What this court said in 2017 was... It
said that focuses on whether the court gives sufficient information based on the record viewed as a whole. It's a little bit different than what you're saying.
What the court said was that the failure to apprise the defendant of, quote, the potential maximum term of his sentence invalidated the plea. And I'd refer Your Honors to the Brown and Thomas cases that we cited in our reply brief, which are third department cases. Those are about open guilty pleas, right? Those are cases where the defendant, they're not conditional pleas, but it's analogous. The defendant pleads guilty with no promised sentence. And in both of those cases, what the third department said was the plea was invalid where the court never told the defendant what the maximum sentence he was facing could be. This is a precisely analogous situation to that. And I think it also follows quite clearly from the K2 line of cases. The whole upshot of those cases is post-release supervision is a portion of the sentence. In order for the defendant to plead guilty knowingly, the court has an affirmative duty to tell him what sentence he's going to receive in terms of the PRS. This is an even worse error. Surely, if you need to be told of the post-release supervision portion of your sentence, you need to be told how much prison time you could serve.
Didn't the court at one point state what the maximum sentence was?
Not on the charge that Mr. Caridad pleaded guilty to. It only said what the maximum sentence would have been on the top count.
On the indictment, yeah.
On the indictment.
Okay.
But Mr. Caridad wasn't pleading to the top count of the indictment. He was left to speculate, look, is the sentence going to be 9 to 18, a year longer than what I got, or is it going to be something greater than that? He just doesn't know because the court doesn't tell him. Again, it was very simple here what the court needed to do. That's all it needed to say was, on the charge you're pleading guilty to, on the top count, if you abscond and you don't appear, I can sentence you up to the maximum of 12 and a half to 25 years. It was not a serious burden. It was the most critical piece of information that the court could have given to Mr. Caridad. It was a direct consequence of the plea, and the court's failure to have advised him of that consequence renders the plea per se invalid. I'd also point out there were some additional problems with this plea. The court also never told Mr. Caridad that it could unilaterally enhance the sentence without giving him the opportunity to withdraw his plea. And under Innis versus Delsheim, the Second Circuit case we cited, that's an additional problem with the plea. And respondent has really provided no compelling reason why we shouldn't have gotten a hearing on our coercion claim. Thank you, Your Honors.
Thank you. You'll have 2 minutes for rebuttal.
Thank you.
May it please the court. Good afternoon. My name is Megan McLaughlin on behalf of the people. At this plea proceeding, this defendant was warned that the promised sentence was conditioned on his reappearance in court, and that if he violated that condition, the sentence would not be binding upon the judge. Regardless of those clear warnings, this defendant fled the country in an apparent attempt to permanently...
Well, we know that, but let me ask you, do the cases state, as defense counsel indicates, that the judge at the plea hearing in 1998, I believe, had to give him exactly the maximum sentences for all the different, for the different charges? Was he required to give him exactly that? I mean, I know he said what you're saying, but did he have to say more?
No, Your Honor. The law does not require the judge to give every single situation and in any violation of the plea. Instead, the Court of Appeals has focused the concern on generally whether the record reflects that the plea represents a voluntary choice among the alternative options open to a defendant. Here, the defendant was told what his promised sentence would be if he accepted and satisfied the conditions, and alternatively, what his sentencing exposure would be if he went to trial instead. He was also told that if he did not appear for court, he would not receive the sentence that he was promised. The defendant had every single piece of information he needed in order to make an informed decision as to whether to take the plea or go to trial. And he also knew everything he needed to do in order to ensure that he got the exact sentence that he bargained for. So the idea that the defendant might not have pled guilty if he knew the exact sentence that he could get if he absconded for 20 years is not reasonable. There is simply no law that requires the judge to have specified the exact sentence that would be imposed if the defendant did abscond. And the cases that my adversary, most if not all of the cases that he points to, have to do with the imposition of post-release supervision, which is completely separate and frankly just not what occurred here. The defendant here, the consequence of his plea was prison time, which he was told, and then he was told that if he absconded, he would receive more prison time, which is exactly what he received. This is not a case where he was not told that the imposition of post-release supervision was possible and then it was later imposed. So it's a completely separate issue in that regard. Additionally, the voluntariness of this plea is clear from the record. After the police physically pulled this defendant off of a woman he was attempting to rape and kill, he was indicted for attempted first-degree murder, attempted first-degree rape, and second-degree kidnapping. He then pled guilty to a generous plea offer that allowed him to plead only to the kidnapping and attempted rape charges in exchange for a promised sentence totaling 8 to 16 years. This was a completely reasonable plea for this defendant to take and want, and all of the circumstances point to its voluntariness. Now, if Your Honor, if the court would like me to address the motion to withdraw
Counsel,
issue.
I have a housekeeping question.
Yes, Your Honor.
The sentencing was on June 1st here, correct?
Yes.
Was there ever an amendment to that sentencing?
No, Your Honor, the sentence is still.
Thank you.
If there are no further questions, I rest on the points in my brief.
Okay. Any further questions? Thank you very much, counsel.
Thank you.
You may proceed.
Thank you, Your Honor. There is no principled basis to distinguish the PRS line of cases from what happened here. There's simply no reason why the post-release supervision portion of a sentence would be a direct consequence, but the prison portion of a sentence wouldn't be. That makes no sense at all, and it's not the law. You have to tell the defendant what his sentence is going to be. It is the most basic thing you have to tell a defendant at the time that he pleads guilty. And in those K2 line of cases, you don't look at was the plea overall favorable. You don't look at would the defendant have pleaded guilty had he actually known about PRS. The court has an affirmative duty to tell the defendant about his sentence. And when the court doesn't do that, the plea is per se invalid. The maximum sentence that the defendant could receive, the court could have said, made a promise as to the sentence he would receive if he didn't appear for sentencing. It could have said, okay, I'm going to sentence you to this. But if it wasn't going to do that, it had to tell him what the sentence he was facing would be. That is a direct consequence of the plea.
You don't think under all the circumstances here that the defendant had that knowledge because the court made clear that if he doesn't appear, all bets off. He had been advised earlier, 25 to life. Isn't that sufficient under the circumstances?
It's not sufficient, Your Honor. That's not the right question to ask. In these direct consequence cases, this is the entire import.
So in other words, the court has to anticipate that the defendant's going to abscond.
The court has to anticipate that the court has to tell the defendant what the direct consequences of his plea will be. The plea is not valid unless the court says during the plea colloquy, these are the direct consequences of your plea, and the most important one is the sentence.
I don't know if it's a direct consequence of his plea or if it's a direct consequence of his not appearing for sentencing and then absconding. That's what it's a direct consequence of.
Your Honor, may I respond?
Sure.
It is absolutely a direct consequence of his plea. There are PRS cases that have to do with conditional pleas. It's true that there was this intervening event of him absconding, but a consequence of the plea was the sentence he could receive. Thank you, Your Honors.
Okay, we'll take another look at your arguments. Thank you both very much for coming in. The last case for argument is Agley versus 21 East 90 Apartments. You may proceed. Good afternoon.
Good afternoon, Your Honors. My name is William Parra from Gallivucci Clark for the appellants. Our position is on appeal is that, first of all, that we've never disputed that there was that a Labor Law 241 violation was established. Our position is that there were material issues of fact that the lower court overlooked with respect to causation.
Like what?
Specifically, there are 5 or 6 areas where the coworker, Mr. Brown, disputes Mr. Agley's description of what happened on the staircase. We only need one. The two most important.
There for a second. Would plaintiff be entitled to summary judgment on the 240 claim based on Brown's account of the accident?
No, Your Honor.
And why is that?
Because he disputes that the critical causation issue that plaintiff attempts to establish with his testimony that the third coworker let go of his weight from underneath.
I'm not sure I'm not sure anyone ever said, I don't think the plaintiff ever said he let go of the weight. He said he let up a little, I don't even really know what that's supposed to mean, but that's what he apparently said, as far as I could read his deposition, that he let up on the weight, meaning maybe he wasn't holding it as tightly. But there is no testimony that I saw that he let go of this metal bed plate.
Your Honor, respectfully, there is, and this is an issue I have with the lower court's decision, that they only rely on plaintiff's day one testimony and on plaintiff's version, apparently, in his motion papers from day one. But the plaintiff testified for 2 days, and he testified on liability on both. And my opposition in the underlying, and we cite a couple of 2 points on his day two, he changes his testimony slightly, and that's one of them. That on the first day I asked.
You have a page number where you said he actually let go? You can find it on rebuttal if you want. I don't mean to interrupt.
Your Honor, it's in our brief, appellant's brief, in the plaintiff's testimony, relevant testimony, and I believe it might be 226 to 228. It's not in the first testimony, which is early on in the record.
Okay.
It's in the second section.
Got it.
And on the first day, I asked him several times, and he would not answer the question. The fourth time, I finally said, "Did you see him take his hands off?" And he qualified by saying, "I observed and felt it." On the second time that we deposed him, he actually said, and I asked him several times, "Did you see him actually release?" And he said, "Yes, his hands were off. I saw him release." He does, and I believe it's 226 or 228 in the record. And so this is one of the issues I had with the decision, that we are supposed to be entitled to every favorable inference of the testimony because we are the non-movements, and the court seemed to go the other way by not acknowledging that if you believe Mr. Brown, this did not happen.
Okay, what other facts do you follow, answer Judge?
Sure, Your Honor. So just going in, the two most relevant were that he never released. Mr. Brown says, "I was next to Mr. Agley looking down." Mr. Agley had said the coworker and the two coworkers were below me holding, and one of them let go. He says, "I'm next to him, so I'm looking down the whole time." And he says, "I never saw Bilal let go. I never felt him let go."
I still don't understand why that matters. I agree, no question, that the testimony is different.
Because if there isn't the release, there isn't the sudden jerk down. And that is the gravity-related issue we have here. It's not just that there was a...
But isn't the gravity-related issue I think, at least a 500-pound piece of metal being taken down on a hand truck down a series of steps?
Sure.
Isn't
yes, Your Honor.
isn't that the instrument that...
But those two things, the weight and the violation alone aren't enough. He still has to prove causation between the violation and his injuries. And if you don't believe that there was this sudden jerk forward, he cannot explain how the violation caused his back.
But by the time, I looked at the picture of the stairs, of the exterior stairs. They're somewhat narrow. There's maybe 10, 12 stairs. I didn't count them exactly, but... so it couldn't have taken that long to get down. And when they got down to the bottom of the stairs, Mr. Brown said that plaintiff said something about, my back is killing me and my shoulder hurts. He did complain about an injury. I pulled my shoulder out, my back is killing me. So he said that's what happened during those, minute or two as he was bringing it down. And that at some point, Mr. Brown heard him say, "Ouch!"
Yes.
So, if it was loosening a little hold on it and not dropping it completely, which still don't think anyone said it quite that way. He yelled out a little bit. What's the problem? There may be differences in the exact testimony, but how are they really material differences?
Your Honor, I believe that Mr. Brown's testimony about an ouch at the bottom has nothing to do with plaintiff's version of events. One thing I'd like to respectfully correct is that Mr. Brown testifies that he never said, as plaintiff claimed that after they lost control off the top step and for one or two steps and regained, that they stopped, that he yelled at Mr. Brown while he regained his composure, that he told them either then or at the bottom of the stairs that he hurt his shoulder and back. Mr. Brown says none of that ever happened, or at least the way he puts it sometimes is, I didn't recall that happening. Mr. Brown's testimony that he said ouch at the bottom of the stairs, but that he doesn't know what happened or why, that is basically testimony about some other incident that the plaintiff doesn't even claim. The plaintiff is very specific about what happened. Coming off the top landing, they lose control for one or two steps. Not that he's at the bottom and he hurts his hand, which is also what Brown says, that he later says, "I hurt my hand." Mr. Agley does not claim a hand injury. He claims off the top step.
I'm sorry, didn't Brown say that he heard plaintiff, when he got to the bottom, saying that he got hurt?
That he got hurt, and that he said he hurt his hand. Not that he hurt his shoulder and shoulder or back.
That's what he
as plaintiff
remembered.
claims.
He remembered plaintiff complaining about only about his hand at that time.
Yes, he may have put it as what I remember, but again, with all favorable inferences coming to the defendant as the opponent to the motion. I think these are credibility issues that should be entitled to argue to a jury. That, Mr. Brown's testimony can be taken to mean that what plaintiff claims very specifically happened at the top of the stairs, that injured his back and his shoulder, for which he's had operations before and after the date of loss, did not happen. That whatever Mr. Brown would say happened at the bottom, which was an ouch, without knowing what caused it, it's a different location, it's a different accident, if you will, that plaintiff doesn't even claim.
Okay, you'll have 2 minutes for rebuttal. Thank you. We'll hear from respondent.
Good afternoon, Your Honors. Just at the outset,
I'm sorry, your name?
Oh, Jeff Sheetzel for Pinion Con for the respondent.
Thank you.
Just at the outset, I'd like to say that, yes, under Mr. Brown's account, the plaintiff would still be entitled to summary judgment. It's a straight runner case, and whether he was injured by...
What about your adversary's point that it goes to causation? Is that a good point?
Well, the entire appeal, since they've conceded the violation of 240 and they've conceded that plaintiff met his prima facie burden, the entire appeal rests on the mischaracterization of Mr. Brown's testimony. What they do in the appeal repeatedly and incorrectly is they characterize "I don't know" as "this didn't happen," or "I don't remember" as "this never happened." Just to give one example, Mr. Brown says, "I don't remember any debris on the steps." They characterize that in their papers as Mr. Brown said there was no debris on the steps. And I don't recall it jerking forward as Mr. Brown saying it never jerked forward. Those are two separate things.
I conceded, but wouldn't that be sufficient if that's the only argument? That would be an issue of fact as to credibility, as to Brown testifying, as to plaintiff testifying?
Under any version of the events, he was injured by the uncontrolled descent of a 500-pound object because he was being asked to act as a human counterweight in violation of 240. There's no dispute that he complained that his back hurt immediately afterwards.
Now you're referencing the incident report, right?
The incident report and the statement to "ow, my back hurt like heck," and the statement of Mr. Brown was this, and this is page 460 of the record. "I remember him saying he hurt himself as to where, I don't know." That pretty much summarizes all of Mr. Brown's testimony as, hey, this was two years ago. It wasn't that important in my life. I don't really remember the facts so well. But the plaintiff has established a prima facie case, and the bottom line is there's nothing Mr. Brown says that raises an issue of fact as to anything material. The witness says he cried out in pain as they were going down the steps. He said he hurt himself afterward. Now, plaintiff doesn't have to prove that every single injury alleged in his BP was immediately apparent at the time of the accident. All he has to prove is that an injury was caused by the violation of 240. Whether that's a strained back, whether that's a popped shoulder. I don't have to prove every single thing in the BP to show that an injury occurred to satisfy the statute. The accident report says lowering a steel plate weighing approximately 500 pounds was holding it back when the hand truck when I felt my shoulder pop. Not inconsistent at all. And if you look at that incident report, there's only a few lines to write. It's obvious they weren't looking for anything more than a summary of what happened. This court has held in the Graminga case, which we cite in our papers, 21082nd 115, the nature and extent of injuries, whether pre-existing, aggravated, or solely induced by this action, are the proper subject of a damages trial and in no way affect entitlement to summary judgment on liability. Once the plaintiff testifies that he was in pain after getting hurt due to a violation of 240, that's it. That's a runner case. And I don't know if the court would like me to address the 241-6 and the 200. I know counsel didn't. I don't.
I mean, if you want us to, I don't know if anybody has any questions about that. I don't think we have any questions about that. I think we were most concerned about the differing testimony as to 240 and what your positions were on that.
Yeah.
Okay, thank you very much.
Thank you, Your Honors.
With respect to Runner, even though analogous on the facts in certain respects, because of the strong, the heavy weight alleged and the small height differential, is distinguishable in the key respect. In the Runner case, all of his coworkers corroborated Runner's account of how the accident occurred. In our case, we do not. Again, given every favorable inference of Mr. Brown's testimony, a jury could reasonably infer that this did not happen, that Bilal never let go, that they never lost control of the weight for any reason.
Couldn't the plaintiff have been injured even without the helper not letting go?
I'm sorry, Your Honor, can I hear that?
Couldn't the plaintiff have been injured without the helper letting go or releasing his hold slightly on the hand truck?
Could he have been injured?
Yes. Isn't that what plaintiff is saying? He gets to the bottom, or at least according to Brown, and he complains about being hurt.
Well, he has to establish it. My argument is that he has made his case on how the violation caused. It's this scenario right here where Mr. Bilal lets go. Anything else?
Why do you say, I mean, you told me that you asked him the same question numerous times.
Yes.
I don't know how you got away with that, but okay, during the deposition in 2 different days. And he did say before that he kind of let off the pressure, it sort of jerked. I mean, why do we have to go with the one thing you say he let go, which he only maybe said one time, and that if he just let off the pressure or it jerked a little bit or it moved, it was while it was going down in a runner type situation with a very heavy steel plate.
Yes, Your Honor. That goes hand in hand with plaintiff's next point related, that as a result of him either letting go of the pressure or completely letting go, which he did say, that they then lost control after going off the top landing for one step. Day 1, he said, we lost control for 1 step before we regained control. Day 2, he said, well, actually, after we went off the top step, we lost control for 2 steps before we regained control. Mr. Brown was there as an eyewitness and said that never happened. And that, plaintiff has made his bed.
Well, that's not precisely what he said. I think going to your adversary's point, that's not precisely what Brown said, but in any event.
Again, Your Honor, it is not precisely what he says, but I think that we can reasonably infer and we can argue that, and we should be allowed to argue that to a jury.
Okay, well, thank you both very much. Appreciate it.
Thank you very much.